The law matters, as we tell you. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program's been created to educate, inform, and help you decide how to protect yourself, your family, and your business. The information and resources we provide may help you to decide that you may be able to handle some issues yourself. At the very least, you'll be better prepared to work with whatever professionals you decide. Our goal, of course, always is to save you time, money, and to achieve the best possible results. We want to continue to welcome and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence. He continues to share his legal expertise and his insights in each session. So today we're going to handle workers' compensation issues, and subsequent lawsuits can be very complicated. In every state, the laws vary. The benefit system is designed, of course, to be no fault, to help you out no matter whether you've had an employer's negligence or carelessness or whatever contributed to your injury or your somehow workplace-related occupational disease. Whatever matters, the only thing that matters is that you were involved in some sort of problem and suffered some sort of injury. So today we're going to cover who's covered, what's covered, what claims are about, what appeals are about, and there's been a long history of what goes on with workers' compensation. And so to set the scene, David, please tell us not only what is workers' compensation, but give us a context or a history of it, if you would.
So workers' compensation sort of developed as part of the beginning of the Industrial Revolution. So the Industrial Revolution was a catalyst for many changes in how people work, labor laws, unions, and workers' compensation. And what happened was, at the time, there was no workers' compensation laws. So if you were injured, and you actually covered a little of this in your open, you had to sue your employer and prove negligence. So you had to prove that they or one of your co-employees who was working for them in a master-servant relationship with your employer did something wrong. And as a result of their negligence, you were injured. And lawsuits take time. So now you have somebody who's working in a factory and is the only breadwinner in the family and can no longer work because of his or her injury, but back then mostly his, because we used to call it workmen's compensation insurance. Yes. And they're out of money and now in desperate times, and there's no recourse until they can get to court after a long period of time and prove a case where there was someone who they're suing that's responsible for their injury. A lot of times people would get hurt at work, and it wasn't necessarily the result of negligence of someone else. They might have been working on a machine and accidentally got their finger or hand or arm caught in the machine and have suffered severe injuries. So there was a compromise reached. And the compromise was that we'll find a way to compensate someone who's hurt at work. So the key was the injury or illness had to arise from and in the scope of their employment, and as a result of that are unable to perform their job, and therefore it will give them compensation and in a quick, expedited manner. In exchange for that, the worker gave up the right to sue his employer and to recover money for pain and suffering and other general type of damages that you might have otherwise been entitled to. And what you would get in exchange is a percentage of what your pay was and medical bills covered, and in some states, in some instances, maybe scarring and loss of use.
Sounds like a good, quick snapshot, and understanding that the reason to do this, as you say, was to expedite it. So even every state varies, but everyone has issues with workers' comp in just about every state that I researched. Ours, of course, in Rhode Island has just been topping the charts with, I think the most recent stats in the past week or so were 54% increase over the decade, and numbers such as people being out for, this seems impossible, David, 30 years, one case lingering. That's the absolute antithesis of something that's supposed to be expedited. What went awry? What happened, David?
So what you're really citing is a limited portion of where workers' compensation is, and that's state workers, state employees.
Fair enough, right.
And a couple of things that you need to understand about that. The 30 years, whatever that might have been, and I'm not familiar with that particular case, wasn't that the award of benefits wasn't expedited. That's what we're talking about when we say expedited. The benefits may have been awarded in an expeditious fashion. The length of time they're on really is part and parcel of a change in the law that wouldn't have affected someone who was injured 30 years ago, because in 1991 they changed the law in Rhode Island, which had a very big change on what you could get for benefits and what you were entitled to and how long you could get those benefits for. For example, one of the things that you could get is if you were partially disabled, meaning you could do some work but not your own work, you could get benefits for as long as you were partially disabled. In 1991, I believe it was, when the law changed, that changed to a 6-year period. That's the max you could get partial disability benefits for. You would either had to retrain into some other kind of work or find something else, or if you couldn't find other work and you could prove that there was nothing else you could do with your education, injury, and ability to work, that type of thing, a vocational tech expert type of looking at your situation, you could fit what's through a gate, which is, I can't do anything, I'm still only partially disabled, so you might get benefits beyond that 6-year period, but it's really hard to go through that gate.
People talk about workers' comp and also disability. Maybe it's temporary disability, but disability. Explain some of the differences, and as most people want to know, there's a difference in payout. Do you want to address that a little bit? We need to back up after a while, but let's cover that.
And we can do that. And as you said at the beginning, every state is different. Every state has its own process or procedure, its own rules as to what you're entitled to or not entitled to, and how long you can collect benefits for. So the difference between total disability and partial disability, at least in Rhode Island, is if you're totally disabled, that means you can not do not only your job, but really any other job for which you have some training or ability to do. So you're totally disabled. It's sort of similar to the standard for Social Security disability. And so if you can't do anything, you're entitled to collect total disability. And if that's something that continues on for a long period of time, you can collect for a long period of time. And partial disability is you can't do your job in particular, but you could do some other work. And so there's a limit on how long in Rhode Island you can collect partial disability.
At the open of the segment, I was about to say, from what I had read, it seems that workers' compensation is clearly not a do-it-yourself issue. At the open, you said it was designed to be an expedited.
Yeah, expedited.
Clearly it's not, even if it isn't state workers, et cetera, and an overburdened system. But is it possible that a workers' compensation case could proceed without having some legal intervention or having a lawyer represent someone? It seems that can't happen. Do you want to address that, David?
So the answer is it can, and it often does, and it shouldn't, and there's a reason why it shouldn't, and I'll get into that. But you get hurt at work, your employer contacts the insurance company that covers the workers' compensation for them. The adjuster from the workers' compensation insurance company will often contact the person who's injured, and they'll start paying them. And in Rhode Island, they'll usually start paying them on what's called a non-prejudicial agreement, which is, we're going to pay you. We're not accepting the fact that you got hurt at work or that your injury arises out of and in the scope of your employment, but we'll pay you for a period of time. And before the end of that 13-week period that they'll pay you for, if they decide, nope, we're not paying you anymore, it's not binding on them to continue paying. So that's what they'll often do, and hope that someone's not injured that badly and they'll be back to work pretty quickly, and we've not accepted the injury, so to speak. Why I said at the beginning of what I was just answering was that it shouldn't be a do-it-yourself process is because in workers' compensation cases, you don't pay the attorney. If you have that situation where you were injured and you're on that non-pred and you go to an attorney and they contact the insurance company and they won't put you on a memorandum of agreement or an agreement that this injury is work-related and the insurance company owns whatever flows from that injury, they would then file a petition to have you put on workers' compensation and have the court order it. And the attorney, if they're successful, is paid for the employee by the employer's insurance company. You don't pay the attorney for that service.
And I guess when we start talking about the process, even with the reason that even with the understanding that you need to prove a case, that could be very difficult for the average employee. So let's talk about who is entitled to workers' compensation. Is everyone?
No, it's someone who's hurt at work, or as you said in the beginning, might have a work-related illness, and they can prove that this illness arose out of and in the course of the scope of their employment. So if you're at work and you lift a box and hurt your back and now can't do your job anymore, you're entitled to workers' compensation. And you're entitled to have your medical bills paid by the workers' compensation insurance company, or employer, if they're self-insured, which the state is, and we can talk about that later. Or you're entitled, if there is surgery, to have them pay for the surgery. And if there's scarring in Rhode Island as a result of that surgery, you're entitled to have compensation for the value of that scar. If there's loss of use, if it's an arm or leg injury and you can't have full use or range of motion, you're entitled to have compensation for that as well. And again, each of those petitions are very difficult to prosecute in workers' compensation court. That's why you need an attorney who's familiar with workers' compensation, because not only do they have to know the law of workers' compensation, they have to know medical and know what they need to look for in a doctor's report, what language needs to be in there, that it's causally related, that the injury is causally related to your injury that occurred at work, that the disability is causally related to that injury. So there's a lot of, I'll call it magic language, or necessary legal language that needs to be in either the report or the testimony. There is no way you would ever want to handle a case like that on your own.
To just continue with the who's eligible, address federal employees and those who are considered independent contractors. Eligible, not eligible.
All right. So by federal employees, you're just talking about a term of whether I'm an employee of somebody or I'm an independent contractor.
Yes.
So if you work for somebody and you're an employee, then you're entitled to workers' compensation. If you're an independent contractor, you're probably not. And the difference is what kind of control the employer has over your work. So if they tell you when to work, where to work, how to work, supply the equipment for your job, the tools or whatever it is, you're probably an employee. If you go when you want to go and leave when you want to leave, bring your own equipment, you may be an independent contractor. So I'm trying to think of an example. You work for a construction company and they're building a house and they bring you in to do the painting. So you bring in your own paint, your own equipment, your own people that work with you, you're an independent contractor. What I tell people is, when you're entering into any kind of work like that, you should have a contract. So you can have, and if you're the employer, you may want to have a contract that says this is an independent contractor, not an employee, so that there's no dispute as to what the arrangement is between the two parties.
That's good information for both sides to be aware of. And then when someone suspects, well, when there's an injury, very likely an employer will be saying, well, just go, Dave, just go see our doctor, he'll take care of you. If someone is not aware, not working with a lawyer, they might not even know or think to ask, is that an objective? Sir, he's a good qualified doctor, but is he the best person for me to speak with right now? Perhaps my lawyer might have something else to say about that. Address that.
You're entitled to choose your own doctor, what doctor you choose to have treat whatever your injury is. So the insurance company and the employer can't interfere with your right to choose your own doctor. The flip side of that is the insurance company, after you've been treating with a doctor and so forth, has a right to have you examined by what they would call an IME, and they use that term, independent medical exam. I would call it an insurance medical exam, perhaps. And they're entitled to have their own doctor look at you and make an assessment as to whether or not the treatment you're receiving is necessary and whether you're able to return to work or not. If your doctor and that doctor disagrees and you end up in court, the court can appoint a third doctor, a court impartial, to examine you and decide whether or not you're able to work.
Okay, so now that we've covered the who might be covered, the what that's covered. People say, I'm on lunch break. I went out on my own to meet someone that's related to work. Something happened. Covered, not covered.
Yeah. So if you're not actually, if you do clock in and clock out and you're not clocked in and you're not on the premises you left, you're not in the scope of your employment. So an injury in that nature is probably not going to be covered, but it gets a lot more complex and interesting than that.
Sure.
So let's suppose you're an employee and your job takes you from home to home to home, and you leave one client's home and you're going to the next and you get into an accident. Are you in the scope of your employment? And the answer on that is probably yes, because you're still getting paid, you're working, you're driving from one house to the next because that's what's required of you by your employer. That's probably covered. Now, if you have one client, you have a break, and then you're going to the next, and you decide to take a detour and frolic, as it might be called, and you go to the shoreline and are eating lunch and looking out at the water, and a big wave comes and crashes and knocks you over, you're probably not in the scope of your employment. And then there's a lot of things in between. So it can be a very gray area and a very interesting area where a lawyer can really dig in on the facts and try to make an argument one way or the other.
And the easy part is if it's lunch break and you're in your cafeteria and something happens, you're on the premises,
right.
Maybe that's a little clearer cut.
It can be. And again, if the employer, so part of this is fact-driven, requires you to eat on the premises because you could be called back or whatever, there's probably a good chance that that would be covered. There's also a lot of interesting issues on what they call the going and coming rule, which is you're going to work and get into an accident or you're coming from work. At what point in time are you considered on the clock, so to speak, and in the course of your employment or not? So there was a case where the employer had a parking lot across the street from the building where you worked. You would park in the employee parking lot where they wanted you to park. You'd cross the street, you'd come in, you'd clock in. So the person parks on the way into work, is out of the car, is crossing the street, gets hit by a car, working or not working, in the course of their employment or not in the course of their employment. And the argument that was made and that was successful was, even though you hadn't checked in, you parked where your employer wanted you to park, you were following their rules where you were supposed to walk, you got hit, that's workers' comp. Of course, it raises a second issue, which is a third-party case, which is the person who hit you wasn't a co-employee coming to work, but somebody who was just driving down the street and is otherwise liable for your injuries. So you have not only the workers' compensation case, but the claim against the negligent driver that hit you.
So that's a personal injury case, and is it a payday for lawyers? Hate to say that, David,
Say what?
But of course it's very interesting for lawyers to have the ability to cover both sides of that because it's very complicated.
And the rules, they're complicated and interesting. Again, you don't get a double recovery, but remember at the very beginning when we described how workers' compensation was created and what you don't get money for pain and suffering. You don't get money for other emotional damages if there are some. You don't get a lot of other things that you would get in a common law negligence case. And you only get perhaps a percentage of your wages when you're entitled to your entire wages. So what happens is you sue for all of your damages against that third party, but then you have to pay back the workers' compensation insurance company a value of what they paid for your damages already. So there's not what they would call double dipping or double recovery.
Good to know. I was going to just ask too about the company events, when you're expected to go to one versus it's sort of at your discretion. Right. How does that impact on whether you have a case?
It's a lot like that going and coming rule I described in that case that we described earlier where they parked and crossed the street. If you're at a required function, even if it's a social function, but your attendance is mandatory, one could make a good argument that that's part of your work. You were expected to be there, you were required to be there, and if something happened there, there's probably a good case to be made that that should be covered. If it's not required and it's just an opportunity to get together to socialize, and you're perhaps chipping in all the employees who are going, probably not a work-related injury and not covered.
Good to know. So we talked earlier about the finger in the equipment, or a box which gave you a back strain, or you got hit by a car on coming and going. How about the things that they call as repetitive stress injuries? Yep. That's such a gray area. Care to address that a little bit?
It can be a gray area, but it's not necessarily a gray area.
Okay.
The big one, especially with typewriters back in the day and computers today, repetitive use of your fingers and hands to type, carpal tunnel syndrome. If you can go and show that as a result of my constantly using my hands at work and I developed this, and the doctor says, yes, that's a competent producing cause of your injury, and that's what more likely than not, or to a reasonable degree of medical certainty, caused your carpal tunnel injury, then that's going to be a repetitive injury that's covered by workers' compensation. Some of them, it's a little bit more of a gray area. And sometimes there's like, well, maybe a percentage of it was caused by this, but a percentage may have been caused by something else, or by different employers. That
must be very interesting too, if there are secondary or
right.
tertiary employers
right.
involved.
And an example of that might be asbestos and asbestosis, or mesothelioma, or whatever injury you might be suffering, and you worked for 3 or 4 or 5 employers that all had asbestos related into that thing, so they may each be responsible for a portion of your injury.
So with some of the ones that seem very obvious, things like a grocery store worker who's using a scanner all day might actually have a claim. Well, maybe not. There's a portion of that pre-existing condition that I guess people are looking to, which means that your work just aggravated or lit up, I guess the expression is. Lit up the aggravation, which you might have had anyway, but now it could be considered a work-related injury. Seems to me like there's a lot for a lawyer to have to flesh out, or a doctor to flesh out, before that hits workers' comp.
Right, and it is a medical issue oftentimes. So the lawyer needs to be able to present it, but you need to have the correct information from the doctor or treating medical provider to be able to present that. So a very common case that you might see is somebody who's got some arthritis in their back, never treated for it, never had a problem with it, worked all the time, and all of a sudden they lifted that box and the doctor says, yep, this is related to the lifting of that box. That's when the symptoms came about. It's a definite, thing we can point to, as opposed to the carpal tunnel, which might be repetitive. And the insurance, or IME, as they might say, well, this is arthritis that's causing this. That's where the disability is coming from. But the answer is, to me, if you were never treating for that before, never had a problem with it before, even though it may have been underlying, sort of the old you take your victim as you find them, if it got lit up, as you said, by this particular incident, then it's work-related.
Good. So in the brief amount of time we have, help us go through what the process is, and I understand that there's an equally long story associated with appeals, but what's the process from, gee, David, I'm coming to you, something happened to me.
Right.
Where
So you come in, oftentimes you might be getting paid, so we'll want to find out from the insurance company if they're paying you under a non-pred, which is that pay you for 13 weeks and then cut you off thing, or a memorandum of agreement where they've accepted the injury. If they haven't, we'll file a petition, what's called an original petition, to establish the injury. Then as you're treating, you don't go back to court until they may try to file a petition to review, to say you've recovered and we shouldn't have to pay you anymore. There may be those other specific petitions we talked about for scarring or loss of use that come in and out along the way, that type of thing. So you have your original petition. I don't know how much time we have, so I'm trying to fit it all in.
A few minutes.
You file your original petition to get put onto workers' comp, and maybe the insurance company doesn't like the decision or you don't like the decision. In Rhode Island, you appeal that to what's called an appellate panel, a three-member panel of judges who will decide whether or not the trial judge did the right thing or not. If you don't like that, you then file to the Supreme Court by what's called a writ of certiorari, which means the court may or may not choose to accept the appeal and decide the case. Now, here's what's very interesting, the change of the law that I talked about that goes way back. We don't have people on for 30 years very often anymore, unless they are injured and can't do anything. However, after the change of the law, strike that, as we say in court, before the change of the law, if someone got on workers' comp and then the insurance company was moving to take them off workers' comp, the original way that was dealt with was by a direct appeal to the Supreme Court. And while that case was under appeal, the insurance company had to continue to pay the injured employee. So what a lawyer would be able to do, and there's one particular lawyer in Rhode Island who did this all the time, who's no longer with us,
yes,
but he would appeal everything because he would keep his clients on for a long period of time while it took for that case to get reached on appeal at the Supreme Court. Mm-hmm. So they changed the law to stop that long period of time people would stay on for appeals, and that's why we have the appellate panel and the Supreme Court taking cases only as they choose, and you don't automatically stay on during that period of time.
Do you have an advantage if you are continuing to have treatment and you're starting to make progress, as opposed to you come to a certain plateau and it seems that no more is going to happen? You are just going to stay at this baseline, which would mean let's close this case right now?
Well, you've reached an end result. And there's a lot of different things that happen when you reach an end result. But whether you're on comp or not at the point where you reach the end result depends how long you've been on comp and whether you're permanently disabled or totally disabled or partially disabled. So if you're partially permanently disabled, you're looking at a 6-year gate unless you can prove there's nothing else you can do. If you're totally disabled and it's permanent, they own you and you're on. And those are the cases that usually will settle by what's called a commutation or lump sum.
Good to know. And I guess I want to say, in defense of lawyers, apparently those who have lawyers and do that appeal process usually have something like 3/4 of the cases that are settled, and settled with something that makes sense for all. Good to know.
Right.
Thank you for going through that so quickly. We thank you for tuning into The Law Matters. We hope you'll continue to stay tuned because, as we say, the law matters to you.